A child who isn't mentioned in a parent's will is called a pretermitted heir, which means omitted heir. In many states, the law assumes that the child was omitted from the will accidentally and gives the child a share of the parent's estate. But does an omitted child have a similar right if the parent's property is distributed through a trust instead of a will? We explore this question in re Estate of Jackson. Walter Jackson and his wife created a revocable inter vivos trust, also referred to as a living trust. A living trust allows a person to place property into a trust while alive and to direct where the property goes after the person dies. The Jacksons put all their property into this trust and named Robena and Harris Butler as the trustees. Jackson's wife died first. When Jackson died, Johnny Benjamin filed a petition with the probate court seeking authority to distribute Jackson's estate. Benjamin alleged that he was Jackson's son and only heir. Although Benjamin didn't submit evidence of these claims, the probate court declared that Benjamin was Jackson's son and only heir. The probate court also issued letters of administration, which gave Benjamin authority to distribute Jackson's estate. But all of Jackson's property was in the living trust, not in his own name. There was nothing left in Jackson's estate for Benjamin to distribute. Within the probate action, Benjamin brought a claim against the Butlers and the trust. Benjamin argued that the state's pretermitted heir statute applied to the living trust. If the statute applied, then Benjamin, as a child not mentioned in the trust documents and Jackson's only heir, would be entitled to all the property in his alleged father's trust. The Butlers opposed Benjamin's claim on two grounds. First, the Butlers argued that Benjamin hadn't proved that he was Jackson's son. On the contrary, Benjamin's birth certificate stated that his father was Kenneth Benjamin. Second, the Butlers argued that the pretermitted heir statute applied only to wills and not to trusts. Thus, the trust's assets should be distributed according to Jackson's instructions, which didn't mention Benjamin. The probate court ruled that the pretermitted heir statute didn't apply to trusts and denied Benjamin's claim to the trust assets. The appellate court affirmed the judgment. The Oklahoma Supreme Court granted cert, agreeing to review the case.